Stop Adani, protect our water for the future generations. My name is David Cole. I am a member of the original Sovereign Tribal Federation, which is a collective of over 100 tribal councils across this continent, which make up the Federation. Each tribal council speaks for their own estate, but together as a collective we are reclaiming our lands back from the illegal occupation we are currently suffering under. As a federation, we stand in unity with our member tribe, the Wangan Jagalingou tribe and their tribal council. And we demand that the Queensland and federal governments cease and desist in their fraudulent and illegal actions immediately. Here's Adrian Burragubba's sovereign position. The Wangan and Jagalingou tribes have never knowingly acquiesced their title nor dominion over the lands to the Crown or corporate Australian government in any form or style. For any agent, agency, assign or officer of the collective Crown to forcibly remove the Wangan and Jagalingou tribes' sovereignty over their tribal lands by refusing to recognise their sovereignty in favour of the Crown's fraudulent claim to title and or sovereignty is to commit ethnic cleansing of the tribe by removing it from the land and the records, and is an act of war and terrorism against the tribe by violating respected international law. At all times, absolute title and sovereignty over the lands of this continent has remained with the sovereign tribes of this continent. Adrian Burragubba is a sovereign tribal man and a member of the original Sovereign Tribal Federation. Adrian Burragubba has followed lawful due process honourably and has served the Queensland and Australian governments and Adani Australia, Glencore Australia Holdings, Hancock Prospecting and Waratah Coal Mine lawful binding notices asserting his sovereign position and challenging all governments' unlawful and illegal occupation of his tribal estate and resources which belong to the tribal land owners. Julia Gillard attended the annual Minerals Council meeting in 2012 and stated the following, and here's the rub: you don't own the minerals, I don't own the minerals. Governments only sell you the right to mine a resource we hold in trust for a sovereign people. They own it and they deserve their share. She is correct. The Queensland government doesn't own the resource. The Australian government doesn't own the resource. Adani doesn't own the resource. And the fraudulent process that are being used to attain those resources is a criminal act and an act of war. The Wangan Jagalingou Tribal Council has demanded that all properties, deeds, assets, rights and estates, etc. belonging to the Wangan Jagalingou people and tribe must be returned immediately to the Wangan and Jagalingou People's Tribe Discretionary Trust immediately. The Queensland and Australian government's failure to cure will constitute an operation of law and be taken as being the respondents' final admissions of the facts. The Queensland and Australian governments, as well as Adani Australia, Glencore Australia Holdings, Hancock Prospecting and Waratah Coal Mine have all been served official lawful notices. The Wangan and Jagalingou Tribal Council has given Adani and the Queensland government sufficient time to remedy the situation. They have simply ignored the tribe's sovereign position, failed to respond to lawfully binding documents, and instead have decided to employ violent authority as an act of war on the Wangan and Jagalingou tribal people's lives, waters and lands. All Wangan and Jagalingou tribal members are protected by their tribal trust and are protected under tribal law. Any attempt by the Queensland and federal governments and Adani agents to forcibly remove the tribal members from Wangan Jagalingou tribal estate is genocide and a criminal act of war. Our sovereign position and statement of facts is as follows. Adrian Burragubba is a sovereign, autochthonous, original tribal descendant of the Wangan and Jagalingou tribes. Adrian stands in his sovereign capacity as a living natural man of the earth. Adrian stands by the truth that the Crown's claim of right over his tribal estate is both unlawful and a criminal act of war. The laws and constitutions the Australian and Queensland governments rely on are invalid under international law. The Queensland and Australian government's claim over Wangan and Jagalingou tribal estate under the false pretense of terra nullius is a fraudulent and criminal act. False in one thing, false in everything. It is trite fact that any matter done or undertaken in a criminal capacity or manner has no standing at law. Statement of facts. On the 27th of May 2019, the Wangan and Jagalingou Tribal Council, through registered mail served upon the Queensland and Australian government, as well as Adani Australia, Glencore Australia Holdings, Hancock Prospecting and Waratah Coal Mine, a lawful notice of rebuttal, which was received by all parties on or around the 31st of May 2019. The notice of rebuttal is a claim by the Wangan and Jagalingou Tribal Council that rebuts and denies any and all claims by the Australian and Queensland governments to any form of ownership, title, dominion or sovereignty over the lands, resources, water, culture, spirituality, song, dance or ceremonies children, women and men of the Wangan and Jagalingou tribes. To date, all notices remain unrebutted. As of the 25th of June 2019, the Australian Government, the Queensland Government, as well as Adani Australia, Glencore Australia Holdings, Hancock Prospecting and Waratah Coal Mine have all acquiesced by silence. As of the 11th of July 2019, Adani Australia and all their heirs, successors, assigns, executors, administrators, parent companies, subsidiaries and financiers have not responded to the notice of rebuttal and other subsequent notices served through lawful and proper means. On the 25th of July 2019, a notice of fault and opportunity to cure was delivered by hand to the Premier of Queensland, and a copy of this notice was served by registered mail to the Speaker of the House in the Australian Government to serve upon every Member of Parliament, the notice of default, the opportunity to cure and all other notices served to date.
We just served 2 documents on the Premier, one for her personally and one for her to pass on to the Speaker of the House, requiring the Speaker of the House to inform all members of the Parliament of the effects of previous notices served in this matter. The documents were accepted by Kylie from her office. We have footage of the service of the documents.
So that you've been served on their behalf, and we'd ask you to make sure they get them because they are matters dealing with trust and trust law, and both of them are out of step at this point in time. We're trying to remedy that and bring them back into step. We're not trying to do anything nasty. We're actually trying to help them because otherwise they are going to end up in mountains of legal trouble.
They have now been served a notice of default and a notice of opportunity to cure that default.
The Queensland and Australian governments, as well as Adani Australia, Glencore Australia Holdings, Hancock Prospecting and Waratah Coal Mine, have not responded to and therefore are in default of this matter. This failure to respond, and now default, is an operation of law and is the respondent's final admission and agreement to the statements and claims made by Adrian Burragubba and the Wangan and Jagalingou Tribal Council. The Australian and Queensland governments, Adani Australia, Glencore Australia Holdings, Hancock Prospecting and Waratah Coal Mine and all their heirs, successors, assigns, executors, administrators, parent companies, subsidiaries and financiers are in default in this matter. The trustee of the original Sovereign Tribal Federation has provided all parties sufficient and fair opportunity to respond. The Queensland and Australian governments, Adani Australia, Glencore Australia Holdings, Hancock Prospecting and Waratah Coal Mine and all their heirs and successors, assigns, executors, administrators, parent companies, subsidiaries and financiers are in default and stand in dishonour. The original Sovereign Tribal Federation is governed by tribal law. First in time, best at law. We have taken our future into our hands and placed our feet firmly back on the path of self-determination as one autochthonous, original collective and determined our way forward. As a federation, we stand united and declare our sovereignty to the world. The Australian government stands in dishonour, operating fraudulently. Cease and desist.
Today represents the first process of us reclaiming our right to our ownership of our land and all of our properties. This is the beginning of the movement for all of us and all of our people to make a declaration of our connection with our ancestor spirits and the water and the rainbow serpent through the Dongball Springs. We now take back our authority. It's no longer their position. The Premier, as a fiduciary, now has to hand in that back to us for our tribal council so that we then deal with our own business in the country.